Good afternoon to honorable guests and respected members present here. And it's my pleasure to introduce our today's guest of honor, Advocate Shri Gawande Sir. He is a renowned expert in the field of intellectual property rights, attorney with more than 15 years of experience. He is a founder and director of Consultancy Private Limited, one of the leading IP law firms in India. He is a registered patent and trademark attorney and has filed and prosecuted more than 3,000 patent applications till date. He is a certified QMS lead auditor from Bureau of Indian Standards and also has formerly worked as an adjunct professor and director as of Technology Incubation Cell at IBS's College of Engineering. He is also an alumna and member of APIC Japanese Patent Office and presently working as a patent consultant for more than 200 educational institutions and industrial organizations globally. He is also acting as a trainer and has conducted various workshops for various institutions and organizations such as MSME, MCED, and Indian Patent Office RGNIIPM. His expertise include patent and IP convincing, prosecution, technology validation, IP commercialization. Today, he will be sharing his insights on identifying intellectual property components at early stage innovation. I request respected Head of Electronics Department, Shri R.M. Garut sir, to welcome our honorable guest with a medicinal plant and a book. Now, I would like to call Advocate Swapnil Gawande Sir to share his thoughts on today's topic.
Last session which I will going to take some intellectual property. A workshop or FDTP which has been organized. It's on basically how we can improve our capacity. In today's era, without having you cannot claim that you have achieved or you have contributed. It is today's bare necessity that you go to criteria qualification for NTA or even for UGC. Now they are making everyone mandatory that what you hold in your IP portfolio because IP portfolio is a thing which actually shows that apart from your academic work, what you have contributed, how you have integrated to develop, innovate something in your institute. And being a technical institute, nowadays, one of us must be aware about this intellectual property. So, moving towards this intellectual property, to understand the of property. When I talk about property, what it that we only look at property from one angle. But property in simple word means anything which you can legally claim that this thing belongs to. That this is that mouse is in my hand. Is this mouse my property? How you can say that this mouse is not my property? Because you don't have any legal document that this mouse was purchased by. If although this mouse is placed here in institute, but that this is a purchase, I have purchased this mouse from the mouse company. Even if it is placed in this institute, I can take it off that because I am having a legal document that it might be kept my property. This property is basically divided into one is tangible form of property, intangible. The basic difference between these types is that tangible form means any property which you have just by sensing that property you can assess what might be the price of it. And all those properties are called as most important for any intellectual is intangible form of property. What exactly this intangible form of property is? The property which although cannot be sensed, but the thing which increases or enhances value. Like a basic example, you gave me a book as a gift. If I take that book to a Raddiwala, I have to sell this book. What price that Raddiwala will be paying to me for that book? 1 rupee. But have you purchased that book at the price of 1 rupee? You might have paid 200 or 300. Now issue arises. The book which Raddiwala is purchasing at 1 rupee, why you paid 300 rupees for that? That means shopkeeper have committed fraud. त्यांनी तुम्हाला मूर्ख बनवलं ना 1 रुपयाची वस्तू 2 रुपयात विकली. नक्कीवाला तुम्हाला मूर्ख बनवत आहे 300 रुपयाची वस्तू 1 रुपयात मागतो. दोनपैकी एक गोष्ट तर खरी राहायला पाहिजे. तर 300ची वस्तू 250 मध्ये मागितली. एक एक्झाम्पल काय, ज्या तुम्ही ते दुकानदार आहे तुम्हाला म्हटलं, तुम्ही त्याला म्हटलं की नाही पहिले भेट तर करून पहिले मटेरियल कोणतं वापरलं ते सांग. त्या मटेरियल बनवलेलं आहे त्याचं 300 रुपये मागत आहे. Have you done that? You purchase that book on that material. You saw what is title of it. Author has written that book. What are content of it. So at Raddiwala, what Raddiwala is looking in that book? Raddiwala is looking, भैया इसका वजन कौन से कागज से बनी हुई है और मटेरियल की कॉस्ट है. तो रद्दीवाला is looking visible form, but you are looking at intangible or invisible form. Can convert 1 rupee book into a 300, because you are not paying for that material, you are paying for the knowledge which that offers, although which cannot be seen by that Raddiwala, but you know value of that paid remaining 290. So this intangible form of property, intellectual property is part of this intangible form of property. What exactly this intellectual property means? Intellectual property in simple word means any property which you create using your intellect. Any property created by you using your intellect is called as intellectual property, or any property to construction. The primary tool is your brain. All those properties are called as intellectual property. This intellectual property is further divided into two. One is industrial property. Under industrial property, again multiple properties come created are industrial property. And the artistic one, only one type of property comes, that is copyright. Now we will, first of all, we will understand what is. So first type of intellectual property is patent. Patent basically protects invention. We will take an example of mineral water. There is one brand of mineral water. Its name is Himalaya. Its name is Oxyrich. Oxyrich is manufactured by Manikchand. If you have seen the bottle of Oxyrich, on that bottle it is written 300%. You look at bottle of Bisleri, Aquafina, Bele, or any other company, they write added minerals, but no one will write added oxygen. Why no other company is writing that? If you look at that bottle, also written patent protected technology. That means Oxyrich has developed a patented product, and that process is protected by the patent. Hence, no other company can access this bottle, because invention is protected. So whenever you are inventing anything, or whenever you are innovating anything, all this many times another question comes, okay, in engineering colleges or there might be a probability that patent might, but in polytechnic college whether patents can be, there is one excellent example of this. You might have seen there is a bike which comes in market also manufactured by Bajaj. If you see advertisement of Bajaj, always for many years they have claimed BTSI technology. What exactly this BTSI technology is? BTSI technology is nothing but dual fuel injection system for car. In their carburetor, there is a dual fuel injection. Bajaj filed patent application for that in 2005, which was granted to them in around 2000. And that patent application was granted to Bajaj after that TVS was going to launch a bike in market. When TVS was going to launch a bike in market, they were also using a dual fuel injection for their carburetor. Bajaj knew that if at this moment we object to that, they will remove those carburetors bikes in market. So what Bajaj did, तो चुप है, त्यांनी काहीच केलं नाही. TVS manufactured those bikes. TVS took orders pan India for those. Yes, when TVS started to transport those bikes, loaded in container, and those bikes reached the showroom, Bajaj Auto went to Delhi High, came कि इस बाइक के अंदर जो कार्बोरेटर है, dual fuel injection, and these bikes get sold in market. दिल्ली हाई कोर्ट ने इंजेक्शन देते हैं कि जो बाइक जहां खड़ी है वहीं खड़ी कर, बाइक आगे. All bikes were standing at the showroom. शोरूम वालों ने केस के हेड ऑफिस में गालियां देना शुरू कर. तो क्या करना है करो, ये बाइक तय करेंगे। टीवीएस को उनके साथ कॉम्प्रोमाइज करना पड़ेगा। जब आपको मंथली रेंट देते हैं कि बाइक अब हम कुछ कर ही नहीं सकते, दिल्ली हाई कोर्ट नहीं, ऑल दोस बाइक्स आर स्टैंडिंग इन दोस after 3 years, decision was not given in favor or against of any. But both companies ultimately reached a consensus. Both companies entered into compromise. इसके बाद हम कार्बोरेटर में डीजल के इंजेक्शन यूज नहीं करेंगे। और इन्होंने बोला ठीक है हम केस वापस लें। Although case was taken up at for a span of 3 years period of the court, और 3 साल के बाद उस बाइक की कीमत क्या होगी? जिनकी बुकिंग हुई थी 3 साल बाद वो बाइक तो TVS faced huge losses in that case. Actually, that is one part. But another part is that there is one polytechnic college in Amravati, government polytechnic. In 1992, students of government polytechnic Amravati done a project for their final year submission, and that project was having dual fuel injection system for cars. Now imagine if they had filed a patent application for which 200 or for which even today Bajaj is claiming such, what benefits might have gained out of it. Or, but issue is that only thing is that we are not aware. Only thing is that a bulk of projects are in our models and no one looks. Another type is trademark. Trademark basically identify. Whenever I say using any product, whenever I say any service, as a customer, any identification mark based on which I can assess that this is which I am taking. What exactly is source or origin of those products? All those identification marks are protected by our. In case of trademark application, the logic is that any identification mark is protected by the origin company. That company stays specific details on the garment. The claim is if a blind customer just by smelling those garments, he will come to know a specific perfume on a garment kind of trademark application. लेकिन आपका नाम होता है लोग टाटा का जो टी है या पार्ले जी का जो पार्ले जी है, तो this thing is protected by our brand. But slogans जो होते हैं, like now every institute is promoting its student the start their project, for starting any project. But issue arises that they are making them aware about intellectual property. What exactly happens? Like one simple example. In around 2019, one of our clients who was what we did, Diwali के time एक hoarding लगा है. His business was completely different. सिर्फ एक गलती होगी उससे, होर्डिंग के नीचे उसने लिखा पहले इस्तेमाल करें फिर विश्वास। इतनी सिंपल लाइन है। क्या लाइन का कहीं भी प्रॉब्लम है तो विश्वास पहले इस्तेमाल। Immediately the घड़ी डिटर्जेंट टीम elaborated to appointed commissioner that they conducted raid at their premises on the ground that you are trying to market in our reputation. By writing that line and they have written that name for that holding, his whole business was stalled for a span of around 3 months. After that, compromise was attained and he faced loss of around 20. Why he faced those losses, which was of no use for this. So issue arises, we have to make our students also aware that designing anything or whenever you are doing something, you must be aware whether you are infringing trademark or anything. Next type of intellectual property. Many times what happens, although your invention might not be your on which you are working, that might not having some inventive thing, but that thing might look different. Like the stand which is that stand, or you put Bata or Arvin on that design number is written. Or take a simple pen. This pen is protected because the color combination which we have used, the way in which like the shape we are protected by your design application. So whenever you are designing any product, or take a simple example of bottle of business. The 300 ml of bottle of Bisleri is having a tube shape. and he will not see any other bottle of that shape in market. Why you don't see that bottle? Because that shape of that bottle is industry. So whenever you are designing any product, and if that product looks unique, the aspect of that product can be protected. Next type of intellectual property is geographical indication. What exactly geographical indication is? Geographical indication is only type of intellectual that individual. The other intellectual property which you have seen, patent, if I am having an invention, I am designing something, I will be filing a these, but geographical indication is only kind of intellectual property. Always like we take a simple example. आपको कशासाठी oranges, नाशिक, पैठण, पैठणी साडी, सपोज मी तुम्हाला प्रोडक्टचं नाव सांगितलं, सिटीचं नाव घेतो. त्या सिटीचं नाव घेतल्याबरोबर तुमच्या डोक्यात now, if the people of that region find geographical, all the product whose name we have taken, all these products are registered under geographical, including the Nagpur oranges. And in that registration, at the time of registration, map is that only people living in this map can sell those products with the name of that. So all these things, Kolhapuri chappal, Kolhapuri chappal, Puderi pagdi, all these things are protected. So if any product is famous because of its geography, it is protected under geographical. Next type and only type of intellectual property is copyright. What exactly copyright is? Research paper you are writing, the project report which you are making, if you are making any musical composition, if you are making a YouTube video, or if you are organizing any kind of conference or that you are holding, all these things are protected by the copyright. But why copyright apart from and separately compared to other rights? Because all other intellectual property hold only one type of right, that is commercial right. If I am having a patent, I am only interested in commercial exploitation of that. If I am having a trademark, I will be interested in commercial exploitation of that. But copyright is only kind of intellectual property which is not only related to commercial exploitation. मला जर आज एक रिसर्च पेपर एका इंटरनॅशनल जर्नल पैसा तर ₹1 भेटत नाही उलट मला माहिती पण मी ते खर्च करून तो पब्लिश का करतो जर्नल कारण मला माझं नाव माझं रेप्युटेशन इम्पॉर्टंट आहे नेम ऑफ ऑथर मध्ये माझं नाव लिहिलेलं आहे so I am not interested to earn anything out of that interested in my name so all these things in which in case of copyright is only type of intellectual property right there are two rights one is commercial right and other is moral right moral right तो खूप चांगलं एक्झाम्पल आहे एक पुस्तक होतं दुनियादारी तुम्ही एक फेमस पिक्चर पाहिला दुनियादारी पिक्चर ऍक्च्युअली 5 वर्ष रखडत पडलेला तो का पडलेला होता कारण दुनियादारी एक आणि त्याच्या प्रोड्युसरनी त्याच्याकडून राईट त्या पुस्तकावरून पिक्चर बनवला पण जेव्हा तो डायरेक्टरकडे प्रोड्युसर घेऊन गेला त्या स्क्रिप्ट तर डायरेक्टरनी म्हटलं जोपर्यंत त्या पुस्तकाचा एंड नाही बघणार तर सक्सेसफुल होणार नाही तर प्रोड्युसर त्या रायटरकडे गेला रायटरने म्हटलं तरी मी तुला पुस्तकाचं पिक्चर विकत द्यायचे पण माझ्या पुस्तक जसा आहे तुला तसाच बनवावं लागेल तुला माझ्या पुस्तकात चेंज करायचा अधिकार देतात अल्टिमेटली आफ्टर डेथ ऑफ दॅट ऑथर द प्रोड्युसर अगेन वेंट टू हिज वाईफ अँड वाईफ पिक्चर तेव्हा जाऊन तो दुनियादारी पिक्चर बनवतो सो दिस इज द युनिकनेस ऑफ कॉर्पोरेट कमर्शियल it also gives author's rights and moral rights along with it. So, it is the first intellectual property which we will see. If is patent because for every academic person, patent is very important as when you are submitting your proposal or whenever NAC comes and they assess, they ask how many patent applications are filed by faculty. What is patent portfolio of your institute? Why government is paying so much emphasis? Because if you see the chart or development of any country, You see the international scenario of global trade. In 2005, USA was filing around 4 lakh patents. Number two was Japan. Japan was filing around 3 lakh patents. Means Indians in India are filing only 50% of. And as said earlier, you see the global about patent, the monopoly of that. If 82% of patents have 82% of industries holding monopoly are foreign companies, and India has to purchase. Then you see scenario of 2014. USA filed 7 lakh patents. Japan filed 3 lakh 50,000 patents. India issued 50,000 patents. Do you know where China was standing? China filed 15 lakh patents, double the number of applications of US. And last year scenario, the whole world filed around 15 lakh patents, and China filed. So total number of applications filed by world, total number of patents filed by. You see the development scenario of China. This was the span 2005 from where China developed. And India and China are not good. But why India started? Because China developed itself actually. The reason why government is promoting more and more inventors, Indian inventors to high patent. They reached to around 1 lakh patent. So this exactly. So first of all, we need to understand patenting is such a difficult task. How what exactly are the patents? How we find patent? Later people say अरे वो PhD कर रहे हैं PhD को और टेक्नोलॉजी ट्रेनिंग क्या आपने PhD वाले सुनते हैं इतने क्या जल्दी कितनी इन्वेंशन है कौन सी इन्वेंशन की और that actually problem is that we look at this kind of invention. First invention is self-employed. That is patent application of Apple. In this patent application, what exactly happens? If my cell phone falls down, immediately through sensor identified what will be the point of contact of the cell phone. And point of contact at card is active. So under no circumstances, my cell phone will get damaged. Another invention is super drone for online delivery that is patent of Amazon. In this patent application, what exactly happens? The patent application of Amazon. In this patent application, what is it? In this patent application of Amazon, whenever you are placing any order, this location that product, it will be tagged there. Don't be carrying that product and immediately delivery can be. Next patent application are robotic bees that perform the function of pollination and increase agricultural yield to any extent. That is patent application of Walmart. Another application is unique by Amazon. Next is compartment funding. This is patent application. Actually, this patent application has created huge. But have you actually seen any of the invention in market? First thing, these applications are supported by world's biggest giant companies, the companies of the ambit which have never existed. They are so big that such kind of companies have never existed in the past week. But still, these inventions have never seen the light of common. But when we look at other inventions, but when we look at other inventions, I, the image which you are seeing, can you guess what image this is? काही guess करू शकता का कशाची? एक व्यक्ती होती जेबी फ्रायडमॅन. जेबी फ्रायडमॅन त्याच्या 3 वर्षाच्या मुलीला घेऊन ज्यूस शॉप मध्ये गेले. When he went to juice shop, त्यांनी 2 ज्यूस ऑर्डर केले. टेबलवर ज्यूस ग्लास ठेवले. त्याची मुलगी ज्या ज्यूस प्यायला जायची स्टॉप होल्ड तर त्याच्या मुलीला ज्यूस पिता येत नव्हतं शेवटी तिला टेबलवर चढवलं आणि मग मुली मग जेबी फ्रायडमॅनला वाटलं हा स्ट्रॉ तर फोल्ड होऊ शकला असता तर what he invented that is foldable straw. This foldable straw was invented by David Franklin. Patent application of foldable straw was filed in 1945. But even today, 60% of foldable straws manufactured globally are manufactured which purchased this patent from JB5. Why this happens? कारण जर कोणची कशासाठी कुठल्या प्रोडक्टचं बनवतो आपण म्हणतो आपल्याला जे टॉईज राहते ब्रिक्स राहतात ब्रिक्सला आपण काय म्हणतो लिगो टॉईज काय लिगो टॉईजच आपल्या डोक्यात येते कारण लिगोनी त्याचं पेटंट घेतलं होतं 20 वर्षापर्यंत लिगोच फक्त ते बनवत ते त्याच्या आज लिगोची जी त्या फील्डमध्ये मोनोपॉली तरी आहे लिगोचे टॉईज तर ही मोनोपॉली तुम्हाला क्रिएट होती तर इमेज विचारची कुत्रा आहे त्याच्या केसांमध्ये आपण मराठीत त्याला कोकरू बोलतो तो फिक्स विचार स्टार्टिंग इज डॉग्स आपल्या घरचा कुत्रा असेल आपण त्याला साफ करून टाकतो बाहेरचा कुत्रा असेल पण एक व्यक्ती होती त्याचं नाव होतं जॉर्जी ने ते जेव्हा मॉर्निंग वॉक करून त्या कुत्र्यासोबत आले तर त्यांनी काय केलं त्या केसांचा सॅम्पल कट केला मायक्रोस्कोप खाली बघितलं की त्याच्या लक्षात आलं की बीड जे राहतात ते कडक राहतात केस सॉफ्ट राहतात ते दोघं जे आहेत दुसऱ्याच्या कॉन्टॅक्ट तर ते गुंडाळले जातात आणि खूप इफेक्ट immediately based on this observation what velcro velcro was invented back imagine for a span of 20 was sold totally by it. So it is not necessary that you are doing something new. Actually when you see the more simpler your invention is there is more strong probability of commercialization but as per survey you know which is the world's most successful invention world's most successful invention तुम्ही पेपर क्लिपची राहते ना पण पेटेंट मला 300 पेक्षा पहिले नॉर्मल पेपर क्लिप होती 2 बुकची पण एकाने त्याला एकाने मग चिमटा आला असे कितीतरी इन्व्हेंशन साध्या पेपर क्लिपवर तुम्ही हायटेक मशिनरी घेतला तुम्हाला हजार कोणची मशिनरी पण जगातला सगळ्यात सक्सेसफुल पेटेंट ऍप्लिकेशन मध्ये फायनल झाला होता पेटेंट होते स्टीफन वेली अँड इन्व्हेंशन वॉज रबर बँड तो आपण डोक्याला लावतो की आपण पेपर गुंडाळण्यासाठी तो पेटेंट ऍप्लिकेशन जसा फाईल झाला होता तो रबर बँड आज सुद्धा आपण जसं ते तसं केली म्हणून rubber band is treated as world's invention because it has not been modified for more than 150. They are using that invention as well. So it is not necessary that you need something very different to find the patent. More simpler your technology, there is power of patent. What power patent can provide to you? तर मी तुम्हाला विचारलं who invented aeroplane? Right brothers? नाव येते का? Actually, in 1905, the first plane which people of USA actually saw flying in the that plane was manufactured owned by Glenn Curtis. Glenn Curtis was a person who manufactured air for the first time. This Glenn Curtis was one of the celebrity creators of USA, and his firm was funded and supported by Mr. Henry, who was owner of Ford Automobile, world's largest automobile, and his second investor was Thomas Alva Edison, owner of world's largest manufacturer. To these Wright brothers were there was a Wright cycle company, and these brothers were owner of that Wright cycle. And these two brothers were one. But why today we take name of Wright? Because in 19 Wright brothers filed a patent before US patent office. In that patent application, had certificated where no one was there apart from he manufactured this plane. He successfully and then we dismantled it. So no one has actually seen the plane. It was actually manufactured and sold by Wright. But till today, after around 125 years, when who invented aeroplane, we take name of it. So that exactly is power of it. What for an individual power will fit it and even fight with world the thing is that development always work in progress. Anytime people say कि अरे मैंने जो काम किया था मुझे बहुत हो गया है or even when people file one patent application they say they are patent पेटंट इन्व्हेन्शन कधी थांबत नाही. One of the landmark example is story of tin जो आहे म्हणजे एक कंटेनर in which you can be sold the goods. And container was invented in by patent. त्यात तुम्ही exactly पण शिपमध्ये जर तुम्हाला ब्रिटिश ज्या इंडियाला यायचे तर कित्येक महिने त्यांना 10 राहावं लागायचं. Major problem was preserving foods. So for that what Peter Durant invented a soldered container. But what Peter Durant forgot to invent how to open that container. तर 1810 मध्ये तो कंटेनर ज्या इन्व्हेंट केला त्याचा वापर सुरू झाला पूर्ण जगाच्या शिप. पण प्रॉब्लेम होता कंटेनरला उघडायचा. तर ते काय करायचे त्या कंटेनर मारून त्याचं ब्लास्ट करायचं. पुष्कळ व्हायचं सोबत दिलं आणि तो कंटेनर मध्ये मिक्स होतो. The food was so precious that you have to eat that. But issue then in 45 years, what was invented? A wooden handle or shape. एक wooden handle घेतलं त्याच्यात or shape लावली त्याला pierce करा आणि कंटेनरचा पट्टा. But to invent this simple invention, it took around 45 years. And this was used till 1845 or 1855 पर्यंत तर मेटल मेटल क्लॉ was used. 1931 मध्ये काय आलं? तिथे इलेक्ट्रिक कॅन ओपनर होती त्याची कॅन ओपनर वापरता. तर याला 1931 लागलं मीन्स आफ्टर 120 इयर्स ही इन्व्हेन्शन 120 वर्ष लागले इलेक्ट्रिक. अब ही इन्व्हेन्शन काही जास्त वर्ष टिकली. When USA had to send their troops to fight the electric can opener going to finish. USA spent $20 billion. $20 billion R&D मध्ये खर्च. ते डेव्हलप दिसते ते तुम्हाला दिसत आहे. It has been taken triangular blade आहे ते तुम्ही तो तुम्ही काढू शकता. आणि त्या इन्व्हेन्शन जे आहे 1950 after 100 years of invention of tin and this was used in 1942 पासून 69 पर्यंत या ब्लेड वापरायचे. 69 मध्ये काय झालं? The greatest inventor and his name was Allen. Allen Press त्याच्या मित्रांसोबत त्यांनी त्याचे कॅन सोबत घेतलेल्या होत्या. पण ज्या ते गेले त्या त्यांच्या लक्षात आलं मग त्यांना काय करावं लागलं ते कॅन फोडा. Allen Press realized की एक्सटर्नल गरज नाही. तर 106 after the 9 years what was invented? The thing which was invented was they use करतात. याच्यात सुद्धा मॉडिफिकेशन येणं सुरू. इट इज नेव्हर दॅट वी एंड्स. प्रत्येक इन्व्हेन्शन मध्ये काही ना काही मॉडिफिकेशन. नाउ इफ आय वांट टू प्रोटेक्ट माय इन्व्हेन्शन हाऊ एक्झॅक्ट. Globally there are two modes in which one is to keep your invention as a trade secret. Another is by way of filing of patent. What exactly is trade secret? Trade secret is nothing but the steps taken by you that your invention will not get discovered. याच्यात काय असतं की कोका-कोलाचं केमिकल कॉन्सन्ट्रेट एफसीजी त्या परफ्यूम मॅन्युफॅक्चरर कंपनी राहतात कुठल्या प्रोसेसची आम्ही तो परफ्यूम या गोष्टी ते स्ट्रिक्टली ट्रेड सिक्रेट मला सांगतात. पण ट्रेड सिक्रेटचा प्रॉब्लेम काय आहे? जर तुम्ही रिव्हर्स इंजिनियर करून टाकलं तर दुसरा ड्रॉबॅक राहतो तो टेक्नॉलॉजीला मारून टाकतो. ट्रेड सिक्रेट इज द बिगेस्ट टेक्नॉलॉजी किलर इन द. कारण होते काय राईट मेथडनी जर त्यांचा पेटंट फाईल केला नसता पलीकडच्या इन्व्हेंटरला पुन्हा झिरो पासून एरोप्लेन बनवावा लागला. तर ट्रेड सिक्रेट केलं असतं त्याच्यानंतर ते इन्व्हेंटर झिरो पासून मॅन्युफॅक्चरिंगची प्रोसेस करावी लागते. या केसमध्ये काय टेक्नॉलॉजी आणि जर राईट मेथड जर त्यांना काही तो टेक्नॉलॉजी सुद्धा व्हॅनिश होते. And one of the best example is silk side. आपण सगळ्यांनी लहानपणी आपल्या आजीकडून एक गोष्ट आहे की आमच्या वेळेला पहिले एका काळी अशी साडी तिला गुंडाळून मागे ही आपण ऐकले बाकीच्या डब्बीमध्ये but one of us sees that means our grandparents are lying to us. Actually, that sari was manufactured in India, which was able to be folded. पण त्या साडीचा प्रॉब्लेम काय होता? ती हँडमेड साडी होती. ते विणकर ती साडी बनवायचे. 3 विणकर मिळून 4 महिने मेहनत करून एक साडी बनवायची. आणि ज्या ब्रिटिशर्स आले आणि त्यांच्यासोबत तरी आले, एका दिवसात साडी. तर 4 लोक मिळून 4 महिन्यात एक साडी बनवत आहे. एक माणूस एका दिवसाला 100 दोघांच्या प्राइसची कंपॅरिझन होणं इम्पॉसिबल. तर त्या केसमध्ये काय झालं? विणकरांचा बिझनेस संपला. पण या विणकरांचा प्रॉब्लेम काय होता? ते यूज टू कीप टेक्नॉलॉजीज ॲज दॅट ट्रेड. ते फक्त त्यांच्या मुलांना शिकवायचे. त्या त्यांच्या मुलांनीच हा धंदा सोडून दिला. तर त्याच्यासोबत ती टेक्नॉलॉजी सुद्धा इव्हन टुडे वेन वी से yeah, achieved much technical advancement. But today we don't have a technology which is built and so technology समाजात वेळेबरोबर to find a solution for that. The solution which is of patent. इन्व्हेंटरने स्वतःहून volunteer शिकवायला पाहिजे. त्याच्यासाठी जो सोल्युशन आला that is Latin word whose English meaning is to grant. Patent is nothing but patent is an agreement between you and government. In this agreement, what exactly happened? You claim that I hold a trade secret. I am ready to teach my trade secret to society. But why will you teach your trade secret? For teaching your trade secret, government wants you monopoly for a specific. की 20,000 तुम्ही तुमच्या ट्रेड सिक्रेट होण्याच्या बदल्यात government will give you 20 years monopoly. No other person without your consent can either manufacture, sell, or even import that product in market, and your invention is protected by the patent. So that exactly is power of patenting, and that exactly is of but agreement between third party. But what exactly happens? What exactly is required to file a patent? If I want to file a patent application, the only word which I must have is an invention. उसका ऐसा आर्टिकल नहीं पहली बुक साइफाई टेक्नोलॉजी है भाई the single word which you need to file a patent is invention. Your invention must hold three qualities: novelty, inventive step, and industrial. If these three qualities are there in your invention, it's your project or your the thing on which you are can be protected by the patent. Now, what is first quality of novelty? Novelty in simple word means की पहले पेटेंट मध्ये गव्हर्नमेंट तुम्हाला 20 वर्षाची मोनोपॉली देते. इट इज अन एग्रीमेंट बिटवीन यू अँड गव्हर्नमेंट जर तुम्हाला काही देते जर तुमचा 2,000 स्क्वेअर फीटचा प्लॉट मला तो प्लॉट विकत घ्यायचा आपण दोघं रजिस्ट्रीमध्ये जातो. पण हे की तुम्ही तो प्लॉट मला दिला अशी रजिस्ट्री कधी होत नाही. मला सुद्धा सांगावं लागेल की तो प्लॉट तुम्ही मला दिला मला काय जोपर्यंत मी हे सांगणार नाही you can take relationship. That government is providing you 20 years monopoly. For that 20 years monopoly, you also need to provide something. You are providing a trade secret which no one else in the world. जर तुम्ही स्वतःच किंवा ग्लोबली ऑलरेडी ती गोष्ट पब्लिक परमिशन can be granted. If you want to file a patent until and unless you file application at patent office, you must not bring that invention in public. If you have already brought that invention in public, nothing from government body. There are few exceptions to this rule. Like if you have published your invention in any recognized scientific journal, in that conference you have not gained any money. The thing, if I go on Google, your whole paper is not visible. That the abstract you very much proper. If that is the scenario, in that case, get an exemption. If you have presented your invention in central government gazetted, if you have disclosed your invention only to a group of people for reasonable time, such within 1 year you can file it. की जसं कॉलेज सुरू व्हायची वेळ राहते तसं मागच्या वर्षी मुलांनी काय प्रोजेक्ट केलं ते एक न्यूज बनवताना की मागच्या वर्षी आमच्या कॉलेजमध्ये 2-3 प्रोजेक्ट झाले. As soon as those that news is published, all your projects become non-patent. So you must never bring your invention in public. Finding it. That is novelty. And quality invention must when to when to step म्हणजे it is an industrial property. तुम्हाला फक्त आर्टिस्टिक गोष्टीसाठी पेटंट भेटत तुमच्या इन्व्हेन्शन करून काहीतरी व्हायला. What benefit your invention must have? At least you are reducing cost of existing technology or you are solving some of the problem of existing. So किती लहान प्रॉब्लेम असेल चालतो. ती मायन्यूट कॉस्ट रिडक्शन असली तरी चालते. तर या दोन पैकी एक बेनिफिट तुमच्या इन्व्हेन्शन पाहिला. तर याच्यापैकी एक बेनिफिट जर तुमच्या इन्व्हेन्शन so second quality which you are inventing that you are reducing cost of existing technology or you are achieving some kind of this is second quality. इंडस्ट्रियल अप्लिकेबिलिटी म्हणजे काय इंडस्ट्रियल तसा अप्लाय आपल्याला ते माहिती असेल तरी चालतं. इंडस्ट्रियल अप्लिकेबिलिटी म्हणजे युअर इन्व्हेन्शन कॅन बी ऍक्च्युअली मॅन्युफॅक्चर. असं तर फक्त काही हायपोथिकल कन्सेप्ट नाही. तर पेटंट अप्लिकेशन वाचल्यानंतर परफॉर्म करता वापरता येईल. युअर इन्व्हेन्शन इज नॉट ए युजलेस इन्व्हेन्शन. जगात एकतरी व्यक्ती राहायला पाहिजे तरी हे राहायला पाहिजे ज्याच्यासाठी but it is better. But because beauty is not a use. Although that painting is very unique, that painting is very beautiful, but it don't hold any kind of use. And hence, any kind of painting. So industrial applicability means the invention can actually be manufactured. हे म्हटलं माझी invention ready for a specific sensor market, and that sensor will be manufactured by that market until and unless someone develops that. So your invention is complete and your invention that is industrial application. So these are the three qualities your invention must have. And having an invention, my invention is having novelty, step. Apart from that, there are few exceptions under which your invention will be non-patented. Quite obvious exceptions. Like which are provided under section 3 and 4 of patent. So for the that is invention related to atomic energy. The atomic energy related invention. Atomic property of government, not of any citizen. Hence you cannot find patent on atomic energy. But the section 3 multiple exceptions required. अशी पहिली exception आहे claiming something frivolous or contrary to interest. But I have found patent अपने people have claimed first they have shown कि सर हमने एक ऐसे डिवाइस बनाई एकदा त्याच्यात वैक्यूम आम्ही क्रिएट केला एकदा तो पेंटिंग घालून टाकला. But consider this kind of thing and they say that but if you are claiming such kind of thing you are going against the of that form. That energy can neither be created nor be destroyed from one form. तुम्ही इनपुट काही देतच नाही आणि ते इन्युमरेबल पिरियड पर्यंत आउटपुट देणार आहे. हे प्रॅक्टिकली गोज अगेन्स्ट द बेसिक such kind of frivolous inventions will not be entertained by. Another is that contrary to public order and law. ही जी इमेज तुम्हाला दिसत आहे it has been taken from one US patent. Title of that patent application was Vicky fingerprint. What that had claimed was a box-like looking device. That तो ज्या बोर्ड टाकले टायटल बघायला that you can cut picture of anyone just for fun. Novelty yes. कारण अशा प्रकारची डिव्हाइस याच्या आधी तुम्ही केली. Inventive step yes. Because in fraction of second you can cut down picture of a person. Industrial applicability yes. There are people who might be interested in such kind of thing and this thing can be actually manufactured. It's not a hypothetical, but still it is not patentable because cutting down the picture of people one against public order and law. So such kind of inventions are not intended public order and law. एक असा आहे गॅम्बलिंग मशीन इज पेटेंटेबल इन यूएस बट इन इंडिया इट इज नॉट पेटेंटेबल कारण गॅम्बलिंग alcoholic beverages are patentable in India. But if you go to Arabic countries, their alcohol is prohibited, so alcoholic beverages are not patentable. कारण त्यांच्या laws मध्ये it is against public order. So this thing can vary from country to country. Next is discovery. मी मेळघाटला गेलो होतो तिथे मला वनस्पती राहिली. मी फक्त ती वनस्पती डिस्कवर केली. So you cannot file patent application for any kind of discovery. स्पेशली करोनाच्या वेळेला तर आमच्याकडे त्यातून एक माणूस यायचा तर मी कडुलिंबाचा पाला घेतला तुळशी चार लोकांना हे तुमचं जरी असलं तरी हे फक्त त्यानंतर तुमचे शो त्याने एक कंटेंट घेतलं त्याची क्वांटिटी ते एक दुसऱ्या हे जोपर्यंत तुम्ही सायंटिफिक प्रूव्ह नाही करू शकता फक्त ऍडमिक्शन साठी तुम्ही अरेंजमेंट अँड रिअरेंजमेंट ऑफ डुप्लिकेशन ऑफ प्राइसिंग मी फक्त एक प्राइस यूएसए मध्ये भेटते इंडिया त्याला 10 लाखात इम्पोर्ट करतो लोक लाखात भारतात पडतो लाखात कशी बनवली ते मटेरियल लहान नंतर त्याच्यावर आणि कशी डिवाइड पण तुम्ही बाकी काउंट केलं इंडियामध्ये घेतली मला 500 रुपये रोजाने लेबर भेटतो रोजाचे तर या कॉस्ट मध्ये डिफरन्स काय इम्पोर्ट ड्युटी काय लागली ट्रान्सपोर्टेशन कॉस्ट काय लागली या गोष्टी कन्सिडर केल्यानंतर आपण फक्त रिव्हर्स इंजिनिअरिंग आहे ही कॉस्ट कटिंग नाहीये त्या गोष्टीला कॉस्ट कटिंग रिव्हर्स इंजिनिअरिंग केली असेल किंवा फक्त पाहिजे की अरेंजमेंट आणि रिअरेंजमेंट केली एक इंडियन पेटंट application पेटंट umbrella patent will draw. In that application, applicant had claimed that umbrella will provide protection from rain and torch will give you light. But it is non-patentable because umbrella is an independent device. Torch is an independent device. They have only fitted that torch on. Umbrella चे function मध्ये ते torch चे फरक पडत नाही काहीच नाही इंडिपेंडेंटली आपलं काम करत टॉर्च लाईट जास्त दिसते का umbrella आपण सोबत फिट झालेलं नाही independent devices. So such kind of inventions are not in reverse engineering. Method of agriculture and horticulture is not patent. Cannot file patent for it. But if you are developed automated irrigation system or equipment or devices for agriculture, all those things, same rule is applicable for medical also. All medical devices are patentable, but way in which patent is done, that process cannot be patented. Then plant animal seeds, clothing one section is covered. That section is section 3K of Indian patent. Current section 3K of Indian patent non-patent. Finally, section 3K of Indian patent, both things are non-patent. Any mathematical equation is non-patent. If you have developed a mathematical equation or formula, if you have developed a mathematical calculation with help of which PRP can all those mathematical equations we cannot find. Any business methodology is non-patent. Business methodology काय राहते ओला आणि उभे राहते the way in which you can order text on that one आपला आहे त्या सगळ्या business methodology झाले for business methodology you cannot find any algorithm cannot be protected algorithm that per se is non-patent तुम्ही पहा सेक्शन 3 मध्ये त्या चार गोष्टी पेटंट mathematical equation non-patent business method non-patent algorithm non-patent पण computer program मध्ये computer program per se is non-patent this is non-patent तुम्ही जर वेबसाईट डेव्हलप केली आहे वेबसाईट पण जर तुमचा कम्प्युटर कुठल्या हार्डवेअर मध्ये भेटेल त्या हार्डवेअर मध्ये जर काही नॉवेल्टी आहे तर कम्प्युटर प्रोग्राम एम्बेडेड विथ तर त्या प्रोसेसमध्ये तुम्ही जर नॉवेल्टी आणि इन्व्हेंट in that case it will be patented, but your software program will be permitted. So these four things are non-patented as per mathematical equation, any business methodology, any algorithm, and is non-patented. And any artistic application, literary artistic work, application of information, yeah, these are patented. These are the prohibitions as per patent. Topography of integrated circuit. आपण asking आहे त्याच्यासाठी integrated तर तुम्ही आयसी डेव्हलप केली असेल तर तुम्हाला गायडन्स सॉफ्टवेअर मध्ये तुम्ही डिझाईन पाहिजे पेटंट ऑफिस application of patent law, then aggregation or duplication of known or any component. This thing is not patent. जर तुमची इन्व्हेंशन या मध्ये येत नसेल, that means you are having an invention for which you can file patent. So what you need to see whether the idea on which I am working or my students are working, the project on which my students are working, whether it is an invention or not. If it is an invention, whether qualities, novelty, inventive step, and industrial application. तर या तीन क्वालिटीज आहेत आणि सेक्शन 3 मला याच्यात ते पडत आहे. जर ते याच्यात येत नाही, that project can be another important thing actually related to section also, that is what to do before filing and acquiring or filing it. बेसिकली काय होते लोकांना आयडिया येते त्या आयडिया सोडा आपण विल टेक एक्झाम्पल ऑफ पीएचडी पीपल सिलेक्ट a टॉपिक फॉर देअर पीएचडी युनिव्हर्सिटीला टॉपिक सबमिट करून टाकतात अप्रूव्हल येऊन जाते मग 3 वर्ष त्या पीएचडी टॉपिकवर काम करतात 3 वर्ष त्याच्यानंतर त्यांचे गाईड सांगतात की आता युनिव्हर्सिटी त्या पीएचडी सबमिशन त्याला पेटंट राहायला पाहिजे मग काय होतं त्यांचे अप्रोच ते आम्हाला ते अप्रोच करतात की त्यांना एका आठवड्यात 4 पेटंट technology which is similar to the PhD or far advanced 10 years ahead of the आता या केसमध्ये काय होऊन जाते माझी 3 वर्षाचा पैसा मेहनत सगळं मी इन्व्हेस्ट केलेली आहे आणि एका 7 दिवसात बेस्ट होतं त्या केसमध्ये काय होतं दॅट इज if it is your PhD or any kind of idea which comes to you first of all at idea stage itself ability service is beautiful कुठलाही टॉपिक घ्या तर because as per by 90% of relevant data is related is only available in patent. Then 30% all आपण जे म्हणतो super journal आहे that holds only हे का होते need to understand who publish academic लोक रिसर्च पेपर पब्लिश करतात industry रिसर्च पेपर if industry find that invention is suitable by industry domain academy is completely banned. Second thing काय ज्यांना नॉलेज आहे पेटेंट they will also never disclose their invention in ते फक्त टेक्निकल पार्ट त्या पेपर मध्ये सांगतात ऍक्च्युअल इन्व्हेंशन so 70% of relevant data is what you must do whenever any idea comes in your mind you think that this idea is unique or त्याच्या सर आम्हाला हेल्प करा मॅडम आम्हाला आम्ही हा प्रोजेक्ट केला आहे त्यात तो प्रोजेक्ट सिलेक्ट केला आहे फर्स्ट कंडक्ट ए पेटेंटेबिलिटी सर्च application tell me what different you will be doing compared to this या केस मध्ये काय होईल तर अशी पेटेंटेबिलिटी सर्च केली त्यावर तुम्हाला आयडिया येऊ दे की एक्झिस्टिंग मार्केट मध्ये ग्लोबली या इन्व्हेंशन त्याच्यात काय मिसिंग आहे सो यू नीड टू ओनली कॉन्सन्ट्रेट ऑन दॅट मिसिंग पार्ट in that case quality of your project or your idea will also improve and you will not waste your time in the 95% done by how you can conduct patentability search although there are paid databases you don't really use any patent. Even from past 15 years only 5 years for the initial 10 years they are using database why because free database is all the data which is One website is Google Patent. Google Patent है. Second is freepatentsonline.com. And one important website is for Indian patent. India.gov.in Indian patent. On this website, first what you need to do, तुम्हाला गुगल पेटेंट वर जायचं, गुगल वर नाही, गुगल पेटेंट वर तुम्हाला कीवर्ड प्रिपेअर करायचे. कीवर्ड टाका, तुम्हाला पूर्ण लिस्ट येईल. गुगल पेटेंट पेक्षा who are starting for the first time, who are conducting patentability, rather than Google patent, go for free patents online. हे आम्ही काय रिकमेंड करतो, कारण गुगल पेटेंट मध्ये काही काय लागतात ते जनरलाइज देतात. पेटेंट online.com चा सगळ्यात मोठा ऍडव्हान्टेज, तुम्ही ज्या कीवर्ड टाकता ते, तर कीवर्ड टाकल्यानंतर तुम्हाला पेटेंट अप्लिकेशन, पण त्याच्या राईट हँड साइडला त्याचा स्कोर देतो की तुमचे जे कीवर्ड आहे याच्या लोकांनी या कीवर्डला जाऊन सर्च केलं तर त्यांना कुठलं पेटेंट अप्लिकेशन, तर तो 1000 पासून स्कोर राहतो. 1900 to be 800 पर्यंत that means they are the most relevant application. त्याच्या खालती जो स्कोर आहे त्या इमिडिएटली डिस्कार्ड. तरी स्कोरिंग सिस्टम खूप महत्त्वाची राहते. प्रोव्हाइडेड बाय फ्री पेटेंट. नॉर्मली फॉर फर्स्ट टाइम ते सर्च करणार आहे, rather than Google patent, try Google patent also, but go for free patents online.com. सर्च सिंप्लिफाई हो जाते विदाउट गूगल और कीवर्ड. then conduct a patentability search. When to conduct a search? Patentability search ही तीन वेळा करायची. तीन वेळा पेटेंटेबिलिटी सर्च करायला पाहिजे. पहिली सर्च त्या स्टेज, मला आयडिया आहे की घरून ज्या इथे येत होतो माझ्या डोक्यात, immediately when I go back, first before touching anything, काम करणे सुरू करणार. पहिले पेटेंटेबिलिटी पाहणार की माझी आयडिया खरंच युनिक आहे तर ग्लोबली त्याच्यात काय झालं, त्यामुळे ती सर्च करणार. सर्च मध्ये मला ते हाय प्रोबॅबिलिटी मला जी आयडिया ऍडव्हान्स गोष्टी मला माझ्या सर्च मध्ये सापडून जाईल. पण मी त्याच्यातून शोधतात की ऑल्दो दोस थिंग्स आर ऍडव्हान्स, त्याच्यात ते वाचल्यावर मला मिसिंग पार्ट सापडल्यानंतर सेकंड सर्च आय विल कंडक्ट ती मिडल स्टेज. त्या मला वाटेल की थोडं कॉन्क्रीट हातात की पुन्हा एकदा सर्च करणार की मध्ये काहीतरी माझं मिस या पिरियड मध्ये जर काही नवीन पब्लिकेशन झाले, पेटंट डेटाबेस जो आहे त्याच्यात दरवर्षी जवळपास अराउंड 20 लाख पेटंट, त्या दरवर्षी 20 लाख अप्लिकेशनचा सर्च करतात. 5-6 महिने होऊन जातात. आपल्या एकदा पाऊस झाला लागते की ते पेटंट अप्लिकेशन, मग तर तुमचं जे सेकंड राहते आणि थर्ड तुमच्या पेटंट तुम्ही रेडी आहे की आता मला पेटंट पाहिजे, पेटेंट सर्च होतो पेटेंटेबल आहे की नाही किंवा प्रोसीड. So this is about patentability search. Last thing, testing is filing application. आपण तो पेटेंट ऍप्लिकेशन फाईल करतो त्याच्यासाठी आपल्याला जे फॉर्म फाईल करायचा, एक आहे फॉर्म 1. तो पहिला फॉर्म राहतो त्याची ऍप्लिकेशन फॉर्म. ऍप्लिकेशन फॉर पेटेंट नॉर्मल ऍप्लिकेशन आहे. only one thing is important, the entity in which your name is written. कुछ काय होते का, चार जणांचा ग्रुप राहतो, एकाला आयडिया राहते पेटेंट काय, बाकीला आयडिया नसते. मग तो काय करतो, एक काम करून माझा ऍप्लिकेशन त्याचं इन्व्हेंटर मध्ये लोक त्याला हो म्हणून देतात, त्याला पेटेंट मध्ये नाव आहे इन्व्हेंटर येतात. बट नीड टू अंडरस्टँड हू इज applicant. Applicant is a person who is actually owner of that. Inventor is a person who has invented that invention. That comes as the invention commercial करनी है, तर रोल नहीं. इन्वेंटर का रोल फक्त इसका होता मी इन्वेंशन इन्वेंट केले तर नाव दोन्ही जागे जाऊ शकते, तर ते नाव दोन्ही जागे जाऊ. तर यू नीड टू सी वेअर युअर नेम इज इन दॅट पेटेंट. मग तुमचं तुम्ही फक्त काही जणांचं थोडंफार कॉन्फिडन्स दॅट इज राईट टू त्याचं नाव ॲज ए इन्व्हेंटर टाका, अप्लिकेंट मध्ये टाका. So that you will have to be aware of. Your name is written. Another is form. Form 2 is what? Form 2 is actual form where you actually disclose your invention or declare your. जसं म्हटलं की पेटंट ऍप्लिकेशन म्हणजे काय? टू टीच युअर इन्व्हेंशन टू सोसायटी. पेटंट ऍप्लिकेशन इज अ टेक्नो लीगल डॉक्युमेंट. It's not a technical research paper or a legal document. It is combination of both. So you need to technically disclose your invention in a legal format. तर त्याचा एक legal way आहे ज्या तुम्ही technically disclose. Given the content and the matters that I have given this invention, most important part is claim. Claim जो राहतो तो actually सगळ्यात important part आहे. तर invention disclose मला पेटंट ग्रँट झालाय. At least one of the claim is granted in that. There cannot be a claimless invention. डिस्क्लोजर जरी काही केलेलं असेल तो क्लेमचा पार्ट राहतो तो तुमचा ग्रँट होतो रिजेक्ट. So claim is very important part of the grant. There is a legal way invention disclosure. Comes another point is sufficiency of disclosure. जेव्हा तुम्हाला पेटंट ऍप्लिकेशन फाईल तुमची मदत न घेता फक्त तुमचा पेटंट ऍप्लिकेशन वाचून the architect must be able to understand that invention and perform that invention. जर मी ती इन्व्हेन्शन फक्त तो पेटंट ऍप्लिकेशन वाचून परफॉर्म नाही करू your application is not sufficient to your invention. This ground for relocation. The application त्या ground वर sufficient रिजेक्ट होतो. त्याच्यामुळे तुमचं application समोरच्याला परफॉर्म करता येईल. Sufficiency of this. Then we'll end this session on these few points. One is misconceptions in relation to patent. First myth is that inventor needs to make a prototype. There is no need to. तुम्हाला तुमची आयडिया पेपरवर उठवता येणार. If you can chalk down that idea on paper, you can directly file a patent application. But if you have not developed it, another thing is that even if you have developed a product, forget about that product. Prototype मध्ये काय होते आपल्याला काहीतरी कॉम्प्रोमाइज मध्ये कंपोनेंट भेटले. Forget that prototype. Imagine की जर मला फिनिश प्रोडक्ट तो विकायचा can be capable to be sold in market. So finished product is a finished product की imagine करून information patent application. तो प्रोटोटाइप तयार केला त्याची इन्फॉर्मेशन प्रोटोटाइपचे कंपोनेंट भेटत नाही म्हणून आपण कॉम्प्रोमाइज बिल्डिंग हे करतो. हे तुमच्या पेटंट ऍप्लिकेशन imagine the finished product and what it is. As means that inventor needs to scientifically explain how or why his invention. Patent application is not a research. Patent office is not at all interested in scientific why your invention. Patent office is purely interested what your invention is, if it is a process, what are the steps in which that process is performed, what result you are getting. If it is a product, what component you have used, how those components are assembled, when you will install that component, and what result that component is providing. Why that component is providing result, what scientific principles are involved, that is not at all interest or lookout of it. So it is part of research paper. So always differentiate between patent application and research. And always understand difference between copyright and when you are publishing a research paper आपण ज्या पब्लिश करतो तो ॲग्रिझम चेक. ॲग्रिझम चेक होते म्हणजे काय? Research paper will protect the way in which you have written that research. It will not protect the invention which is hidden in that research. If you want to protect your invention, the only option to be research paper ज्या पब्लिश त्याच्यातून काय काय पेटंट जनरेट करतात. So that is why when you are publishing a research paper, never disclose key of your research paper. Key of your invention has to be a patent application. We recognize people जे research paper पहा ते सायंटिफिक एक्सपेरिमेंटल डेटा काय होता त्याच्यावर बोलतील त्याचे ट्रायल्स काय घेतले बोलतील कोणकोणते एक्सपेरिमेंट केले काय रिझल्ट केले because they know that it is only related to way in which I am writing. It is not protecting my invention. So research paper must not disclose good facts. Last thing is common premature disclosure. Till and unless file a patent, but disclose your invention. If you have to disclose your invention, not disclose. Non-disclosure agreement is freely available on Google. For the format of non-disclosure agreement टाका. तो साइडचे पेपर देखील टाका. तर तुम्हाला जसं तुम्ही डेव्हलप करत आहे मला फॅक्टरी मला फॅक्टरीकडे मदत घ्यावी लागेल की त्या केसमध्ये त्याच्यात नॉन डिस्क्लोजर अग्रीमेंट आहे की आपण कॉलेजमध्ये आपला प्रोजेक्ट ठेवला आपण हायर ऑथॉरिटी येते ते 4 लोकांना घेऊन जाते त्यानंतर हे कॉलेज आहे प्रोजेक्ट आपण सरकार आहे त्याला आवडेल वाटल्याचं नॉन डिस्क्लोजर अग्रीमेंट साइन केल्यानंतर त्याचा जर डॉक्युमेंट एव्हिडन्स क्रिएट झाला आहे तर आपण त्याची नॉवेल्टी संपली आहे so that was about the patentability. If you are having any question, it is also available on ipindia.gov. Sir, net directory website is actually important for everyone. आपल्याला सगळ्यात आधी आयडेंटिफाय करावं लागेल आता बिझनेस करायला तर त्याच्यासाठी तुम्हाला पूर्ण 45 क्लासेस मला स्पायसेसचा बिझनेस करायचा मला स्पायसेसचा बिझनेस करायचा तर माझा क्लास कोणता याचा क्लास आयडेंटिफाय करू शकतो गुगलवर जा गुगलवर टाईप करा ट्रेडमार्क क्लास फॉर मेटल केमिकल स्पायसेस मार्केट ग्रोसरी शॉप तुम्हाला तो क्लास सांगू क्लास चालू तुम्ही काय करता त्या वेबसाईटवर कंटेंट वर नाव टाकून नाव टाकलं तुम्ही इन्व्हेंशन एक्सप्रेस करू शकता तर मला वाटतं की कार्पेंटर कोणी पेन नाही म्हणणार कोणी पेन्सिल म्हणणार कोणी डिव्हाइस पर राईट डाऊट पण त्या केसमध्ये काय करणार तुम्ही डाटाच्या जागी नॅशनल स्पेसिफिकेशन मध्ये हजार तुम्ही एकदा केलं की डाटा तर दोन गोष्टी वर्ड असतील इंडियन पेटंट ऑफिसच्या साईटमध्ये ऑप्शन नाही मला दोन वर्ड जर मी तर मला कार्पोरेटर एकाच टाकावा लागला पुन्हा डाटा द्यावा तर प्रत्येक वर्ड तुम्हाला वेगवेगळ्या लाईन मध्ये द्यावा पण प्री पेटंट मध्ये काय तुम्ही पूर्ण कार्पोरेट तुम्हाला सर्च करून ठेवतील त्याच्यात नाही त्यामध्ये तुम्हाला एका ड्युअल दुसऱ्या असे वर्ड टाकायचे जर तुम्ही एकाच दोन वर्ड दिले तर पूर्ण हे करू आता ऍप्लिकेशन नंबर नाही आहे म्हणून त्याच्यात जाणार नाही त्याच्यामध्ये त्यांनी ड्युअल इंजेक्शन सर्च केली मग 918 सोबत झाले अब 989 हा जो खाली स्कोर पडतो नॉर्मली आपण हे जे आहे 700 चे खालचे जे राहतात ते बिलकुल अवेलेबल राहतात पण बदलत नाही मला जे जे कीवर्ड सुटेबल राहतात ते तुम्हाला जर यूएसचे नाही पाहिजे तो करा यूएस म्हणून बाकीचे ऍप्लिकेशन
Importance of intellectual property rights. The expertise has truly said that the importance of patent and creativity in English today's world. I would like to call the inventors, sir.